frankly, some clever objections to the motion and to the evidence. Suffice to say, I don't believe it does anything to defeat the motion for summary judgment. I find their evidence, frankly, lacking. I don't believe, in subject to being corrected, I don't believe there is any denial of the contract by the defendants, and I'm checking that as I'm talking here. But I believe there's an unsworn declaration by Mr. Kent Brooks. I'm not sure of his relationship to the transaction. However, for those reasons, Your Honor, we ask for the court to grant summary judgment. We think the evidence is sufficient, and it's really as simple as that. Thank you.
Response?
Yes, Your Honor. We have objections to some of their documentation. I think in large part, and I don't know if it was a clerical error or whatnot, but they haven't. Well, let me just basically say that I believe the court should deny the motion for a variety of reasons. One, I don't believe they presented any evidence of any agreement. They attach several versions of an agreement, or I shouldn't say several versions, agreement plus an extension. There's no one sponsored it. There's no identification as to the specific terms. What counsel keeps referring to as the sales price, what they're really talking about is the listing price. But before you even get there, for summary judgment purposes, the contract's not even before this court, Your Honor. They have not even made reference to the contracts in any of their supporting affidavits or declarations.
Was there a transaction?
There was a transaction, Your Honor, and so, but I guess my point is they haven't met their burden to establish an agreement for summary judgment purposes. There's also no evidence of a breach and no evidence of any amount of damages. But I think what the counsel is referring to, and he refers to as clever, but it's not clever. It's actually the Texas Occupation Code. Is they have the obligation to prove in a real estate commission context, not only they have to prove, as they say, the existence of valid contract, the performance and tendered performance, the defendant breached the contract, and that they suffered damage, which they haven't done any of that. But the two things that they have to do in a real estate commission contract under 1101.806, they have to plead and prove that the party suing has a real estate license, and they have not done that. And they have sued under an entity called Athens Real Estate Agency. Athens Real Estate Agency is a DBA for Athens and Athens Enterprise LLC. That LLC is not licensed to practice or licensed to have a real. They're not a licensed real estate broker. I could show you the statutes if you want to. If I can, it clearly shows.
Did you want to share screen it?
Yeah. Do you mind?
Sure. Just give me a second. Go ahead.
Okay, this is, so I can see it here. Okay, this is Texas Occupation Code 1101.806. It's cited in our response. It's very clear, as you see in B, says a person may not maintain an action to collect compensation for an act or as a broker or sales agent that is performed in this state unless the person alleging alleges and proves that the person was a licensed holder at the time the act was commenced. They have not done that. There's no mention, no discussion. So from that purpose, from that standpoint, I think their motion is fatally flawed. I don't believe, because we've done the research and looked at it, that in fact Athos and Athos Enterprise LLC is in fact not licensed is not a licensed real estate agent. So I believe the agreement itself is unenforceable for that reason. If nothing else, it certainly is a fact issue. But I think that this is a fatal flaw, and I believe that in response to the request for admissions, which we've attached to our response, they clearly acknowledge that Athos and Athos Real Estate Agency, or plaintiff has acknowledged that Athos and Athos Real Estate, or Athos Real Estate Agency, is the assumed name for Athos and Athos Enterprise LLC. Again, also cited in our brief, it says that 22 Texas Administrative Code 535.4 subsection G. I'll bring that up. You look, that clearly states a business entity. Can you see that?
Yes.
Okay. So the business entity owned by a broker or sales agent, which I believe that is the case here, which receives compensation on behalf of license holder, must be licensed as a broker under the act. And this is a failure to be licensed and collect a commission is a Class A misdemeanor. And I'll show you Texas Occupation Code even kind of nails it down even more. It says that unless that's 1101.351 says unless business entity holds a license issued under this chapter, the entity may not act as a broker. The entity we're talking about is the Athos Real Estate Agency, DBA, Athos and Athos Enterprise LLC. I think that, Your Honor, is the, that is the fatal flaw. I don't believe they can overcome that, but they certainly aren't entitled to summary judgment. I can go through their evidence. I don't know if you
Let's
want
deal with that issue first.
I'm sorry.
Let's deal with that issue first. So
Okay.
let's hear from the other side.
Thank you, Your Honor. First and foremost, we did not agree that he is that my client is not licensed. And I'm looking at the request for admissions right now, so I don't know, and I think that's what was represented, but we certainly don't agree with that. The client is licensed. There was an issue where he was under probation, but he was still authorized to represent people and list their homes and be their agent. But all that to say, other than citing to parts of the occupation code and maybe administrative code, there's nothing from the defendants that actually shows or is any evidence that my client's capacity as a broker is in any way or was in any way impaired. The contract itself sets out the capacity of the parties. Again, this is why we use these what I call standard forms from the Texas Real Estate Commission. And the defendant certainly did not raise that issue when my client was selling and sold their house for them.
Do you affirmatively establish anywhere in your briefing that your client is licensed?
That issue, let me see here, Your Honor. So I think well, I don't want to speak without being sure. The answer is, Your Honor, we allege and we establish that we entered into a written agreement whereby, and this is paragraph 7, whereby plaintiff would represent defendants in the sale of their property. For doing this, plaintiff would be entitled to 6% commission. In all candor, Your Honor, I don't think we explicitly say he is licensed, because that is obviously assumed in the contract, and there's no evidence that he's not licensed. So
I mean, my initial thought on this is that he's right. You do have to show that under the statute. If you didn't do that, I mean, I can understand why you didn't, but I think that in order to prevail on a summary judgment, you would need to establish that. So my thought is either you pass on your summary judgment now or I deny it without prejudice, and then you clear that issue up.
I would prefer to clear it up, Your Honor, because I know we can. So
Okay.
Yeah.
So you want to pass it for now?
Yeah, let's pass for now. And I think that's fair, to be honest.
Okay.
I think that makes sense. Yeah.
Well, let's get that fixed and then we can figure out the rest of it.
Great. That makes sense, Your Honor.
You have a great rest of your day.
You too. Thank you so much.
All right.
Bye-bye.
Bye-bye. I think we have a 2 o'clock hearing. I don't know if everyone is here yet. The 145 hearing, Haley Childers versus Allied Waste Systems. Is everyone here on that?
Yes, Your Honor. My camera's not turning on for some reason.
Who is that? Who's speaking?
I'm sorry, Your Honor. This is John Grennan on behalf of the plaintiffs.
Okay.
My camera is, there it goes. Sorry, Your Honor.
Oh, no problem. All right. Anyone else here on that case?
Sadie Horner here. I represent Allied Waste Systems and Leonard Walker.
Is Ms. Stubbs here on that case as well?
No, Your Honor, I'm here for the 2 o'clock hearing.
Okay. All righty. Well, let's go ahead and get started.
I'm sorry, Your Honor, we appear to be missing counsel for co-defendant Paul Essendorf, who's named the counsel.
Do you want to call them and see if they want to join us?
Sure. Let me get his number and I'll see if I can find out what's going on. Thank you.
Have you been able to reach? Have you been able to reach? Other counties?
No, I found his number and I called him, no answer, and it says the voicemail box is full, so I can't leave him a message either. John, have you heard anything from him?
I have not. He's kind of been MIA.
Yeah,
Is that Carson Young?
that is.
No. Mr. Young, what are you here for?
Yes, Your Honor, I'm here for the Fisher hearing.
Okay. Is that set for 2 o'clock?
Yes, I believe so.
Rhonda, are you there?
Yes, Judge.
Can you go get Gary for me?
Yes.
Well, guys, it's up to you. The hearing you get, if we want to have this hearing, we need to do it now because I have another hearing starting at 2.
Absolutely, Judge. This has sort of been a pattern of behavior, so I would like to go ahead and have my motion to compel co-defendants disclosures heard.
All right, let's go on the record on DC 216913 Haley Childers versus Allied Waste Systems, Inc. Counsel, make your appearances.
John Grinnan on behalf of the plaintiffs.
Sadie Horner on behalf of defendants Allied Waste Systems and Leonard Walker.
And Mr. Horner, Ms. Horner, I mean, you contacted co-defendants counsel, and I understand that they're not here and they did not pick up when you called. Is that correct?
That's correct, and his voicemail box was full, so I could not leave a voice message either.
Let's proceed.
Okay, for defendant's motion to compel Mr. Freddie David Santos discovery responses, we're specifically seeking to compel his disclosure responses. The case was filed after the new required disclosure rules went into effect in January of 2021. Co-defendant's disclosures were due 30 days after he filed his answer. His answer was filed July 1st, 2021. And to date, we have not received a copy of any disclosures from the co-defendant. So we're asking for an order requiring him to make those disclosures within 7 days of the ruling.
So I see an order in here. Let me see if I can share screen this. I don't think this is the correct order, but I just want to make sure. This is not the order you want me to sign today, correct?
Does it look like a checklist?
Yeah.
That is on the other motion that's at issue today. There was a second proposed order that was filed about the same time as this one that's in connected with the motion to compel co-defendants discovery.
Okay, let me see. All right, let me see if I can find the other order. Is this the one you wanted me to sign?
Yes.
And Judge, we obviously have no opposition to this.
To this particular order?
No, not at all. We were still waiting on them too.
Okay. And then the other, is there 2 motions that compel today or just one?
2. There was this one and then a motion to compel the plaintiff's discovery responses, and Mr. Grinnan is here for that one.
Okay. Have you guys conferred on, so there's quite a few responses here. Have you guys conferred on every one of these?
We have, oh, sorry, go ahead, John.
I was going to say, Your Honor, we haven't conferred on every single one of these. We've been supplementing our production on an ongoing basis. I think we've supplemented our production or our responses 9 times since June of 2022. We've produced over 240 pages of documents since then, and we continue to produce documents. And so we're happy to continue working with the defendants to try to resolve this without the necessity of having the court intervene. But we've been working in good faith with Ms. Horner's office, and we will continue to do so.
Okay,
We did receive a bunch of documents, over 200 documents in a supplement last night. And I did look at them this morning, and they resolved some of the discovery requests that were originally the subject of the motion to compel, but not all. I honestly, John, if you've got some time this afternoon, I'd be happy to hop on a phone call and see if we can do this.
you want me to just put you guys into a breakout room and then you can
That'd be great.
try to work it out?
Yeah,
Sure.
All right, because I have another hearing at 2.
yeah, sure, no problem. That'd be great.
And that's just the 2 of you guys, right?
Yeah, just us.
Thanks, Your Honor.
Then just come back in when you're done, one way or the other.
Okay,
Thank you, Your Honor.
Good luck, guys.
thank you.
Is everyone here on the motion to seal, or are we waiting on anybody?
Judge Seymour Roberts for Cliff Fisher and Company. I think I'll be the only lawyer. I'm flying solo today for us.
Okay. Mr. Young, you're here on that as well?
Yes, Your Honor. I'm here on behalf of defendants Ted Uselak and Larry Teal in place of Alan Lowenson.
Okay. Are we expecting anyone else to show up? Is anyone from Mr. Lynn's office going to be here?
I saw Holly Stubbs on the screen, and there she is right now.
Okay.
And Judge, I hope you're sitting down because we have an agreed order. I don't want you to faint and hit your head.
I don't know if that's ever happened. Is Miss Horner on this case or another case?
Oh, sorry, Judge. I'm trying to get into the breakout room, but I didn't see an invite.
Yeah,
I-
they sent me to the breakout room, and then I left the breakout room and came back
oops,
here.
okay. Apologize about that. There you go. Did you get it, Miss
Thank
Horner?
you.
All right. Okay, then we have Mr. Seymour. All right, Tony, you ready? Tony, you ready?
I'm sorry, I didn't realize I was on mute. I'm ready.
Let's go on the record on DC 1917340 Fisher v. Fisher. Council, make your appearances.
Holly Stubbs on behalf of Gail Corder Fisher, plaintiff.
Seymour Roberts Jr. of Friedman and Feiger for Cliff Fisher and Clifford Fisher and Company.
Carson Young with McCool Smith on behalf of defendants Ted Uselak and Larry Teal.
All right. First off, we have a motion to seal. Gary, my bailiff, if you could check the halls to see if there's anyone here on this case. It's Fisher v. Fisher. You could call the halls to see if there's anyone here who's going to appear.
Yes, sir.
Okay. Once he gets back, we'll get started. Are you waiting for Garrett Blevins? Is he on this case?
No, Judge, he's an intern at our firm.
Okay. Is Gary back?
He's here.
There is no one here by that name.
No one here on that case?
That is correct.
All right, let's go ahead and proceed.
Well, Judge, Gail Fisher filed a motion to seal a specific pleading. She wants to file a motion to modify the temporary injunction that was entered by this court banning Gail from the office. She wants to file a motion to modify that because they want to take discovery in the family court, and they want to take it regarding one of our clients or one or more of our clients. And the TI says that Gail can't contact any of our clients. So the motion to modify is to modify the temporary injunction so that they can take the deposition of FedEx and or other clients of the company. They want to file it under seal because they have information that they believe is sensitive, financial information from the company. And so they want the motion to modify the TI and all responsive pleadings to be filed under seal. We agree with that. And we have negotiated an agreed order. And Ms. Stubbs has submitted it. And it's all kind of a formality at this point, other than the fact that we need to have a hearing today. I believe Ms. Stubbs has done everything she is required to do to post and to provide notice to the Supreme Court and to the clerk of your court. So we agree with it.
Can I just make a suggestion here? I have no problem with sealing it, but it says all pleadings filed in response to Gail's motion for relief shall be filed under seal. At the hearing, all exhibits will be produced under seal. I think it would probably be a lot better if you went ahead and notated exactly what you're talking about, because if this gets filed with the clerk's office, they may not know exactly what they're supposed to seal, if that makes sense.
Do you mean the agreed order, Judge Hoffman? You want us to alter the agreed order?
Alter the agreed order so that it says exactly what, I'm sorry if I misspoke. If
No,
it
no,
says that, to make it clear exactly what's supposed to be sealed. And then I would encourage you guys to follow up with the clerks to say, hey, look, this needs to be sealed. Because if you just put something very nebulous like that, they may not know exactly what you're talking about. It may not get sealed.
Thank you, Your Honor. We'll do that. We'll make the adjustments and then refile the agreed order.
Okay, just make sure that you put down that this was heard on November 14th, 2022, that you e-file it and email it to Rhonda.
We'll do that, Judge.
All right, guys, you have a great rest of your day, okay?